Welcome to the deep dive. Get ready to plunge into the kind of legal battle that starts with one person sentencing in a local courtroom, but somehow escalates into this full-blown showdown at the very top, redefining how judges must apply the law across an entire state. And at the heart of this journey is a really fundamental question. When a law explicitly tells a judge they absolutely must perform a specific assessment, and they don't clearly show they did it in their reasons, is that just a simple mistake,
Yeah.
something that can be corrected later?
Or is it something much more serious? Does it mean they acted outside their legal authority entirely?
Exactly.
And this dramatic question played out in the case of Stanley v. Director of Public Prosecutions,
Mm.
NSW. It focused on a critical decision point in sentencing law, whether someone convicted of a crime should serve their time in full-time prison or through an intensive correction order, an ICO.
Right, the community-based option.
That's it. Served in the community, but under strict conditions.
And you, our listener, brought us the sources that tell this story. So our mission today is to dive deep into this case, follow its twists and turns through the New South Wales courts, all the way up to the High Court of Australia. We'll meet the people involved, untangle that core legal puzzle, and see the very real impact this decision has had. Okay, let's unpack this. So every compelling story has its key figures, right? And this legal drama, it really begins with Emma Jane Stanley. Our sources describe her situation. She pleaded guilty to firearms offenses, specifically relating to storing and selling guns and ammo from her home. Her involvement, well, it appears somewhat limited, particularly financially. She apparently only got $50 from a $6,000 sale.
Yeah, quite peripheral in that sense.
But beyond the charges, she was a person with a background of disadvantage, a mother of 5 kids, and she also had a history of employment. Her personal circumstances and the sentence she got, they were the catalyst for this entire significant legal challenge.
Then we have Judge Williams, who presided over the appeal in the district court. Her sentencing decision became the absolute focus. When considering the possibility of an ICO for Ms. Stanley, Judge Williams actually stated she gave very close consideration to that option.
Okay.
She also emphasized community safety as the paramount concern, noting the risks posed by, well, numerous firearms being present, especially somewhere like Dubbo.
Right, and yet the pivotal issue wasn't really what she says she considered, but what her written reasons didn't explicitly show. Is that it?
Precisely.
Yeah.
While she mentioned close consideration and paramount safety, her reasons crucially lacked any express reference or specific findings showing she had performed a very particular assessment required by the law. That omission, the lack of clear demonstration of that specific step, became the heart of the legal challenge.
And behind these central figures are the legal teams, the solicitors and barristers. They're not just supporting characters, they are absolutely essential players here.
Completely.
They shape the arguments, navigate these incredibly complex procedural paths at each level, and basically translate the human story and the legal principles into the language the court understands. What's interesting is how the makeup of these teams shifts, different counsels stepping in as the case gets bigger and moves up the ladder. Their strategic choices are fundamental.
Absolutely. And the first event, the spark that lit the fuse, was the sentencing hearing in the local court of New South Wales. That was back on 8 December 2020.
Okay.
The magistrate there imposed an aggregate sentence, 3 years imprisonment with a non-parole period of 2 years. So this meant Ms. Stanley was facing full-time custody.
And the reaction from her legal team, I gather it was pretty swift.
Immediate. Determined. Our sources really emphasized the rapid action lodging an appeal to the district court on the very same day as the sentencing.
Wow. Same day.
Yep. And not only that, they also managed to get bail for Ms. Stanley while the appeal was pending. So this wasn't just a mild disagreement. It was a clear, forceful challenge right from the start, signaling that the argument for an ICO was absolutely central to their strategy.
Okay, so stage 1, the local court sentence, immediately appealed. Stage 2 is the district court.
That's right. The case moved up to the district court for the first appeal. This was an appeal against the severity of the sentence, basically. Ms. Stanley arguing the sentence was too harsh. The district court hears these appeals by way of a rehearing, so they effectively look at the evidence and arguments fresh.
And the goal was to argue for the ICO instead of prison time.
Exactly. The core objective for Ms. Stanley's legal team was to persuade the court that an ICO was the appropriate alternative here.
And Judge Williams presided over this appeal. Can you walk us through the specific legal framework she had to work within when thinking about that ICO?
Sure. So the power for a court to make an intensive correction order comes from Section 7 of the Crime Sentencing Procedure Act, 1999 in New South Wales.
Yeah.
We just call it the CSP Act.
Okay, CSP Act. Got it.
But, crucially, that power isn't unlimited. It's subject to some pretty significant requirements laid out in Section 66 of the same Act, and particularly subsection 2 of Section 66.
Okay, Section 66. Now, this is where the exact words Parliament used become absolutely critical, isn't it? Section 66 is titled Community Safety and Other Considerations, and it makes community safety the paramount consideration when deciding on an ICO. But subsection 2, it doesn't just say think about safety, it mandates something very specific. An assessment.
Yes, that's the key word. It requires the court, when considering community safety, to assess whether serving the sentence by way of an ICO or full-time detention is more likely to address the offender's risk of reoffending.
So it's not just thinking about safety in general, it's like comparing the two options specifically on the reoffending risk.
Exactly. It's a directed comparative assessment. Which path, the ICO or prison, is more likely to reduce the chance of this specific offender committing crimes again? It's forward-looking.
So looking back at Judge Williams's reasons, she said she gave very close consideration to the ICO. She emphasized community safety, the risk from the firearms. What was the problem then, legally speaking?
The problem, which became the focus later on, was that her written reasons did not contain any express reference or specific findings showing that she had actually performed that specific comparative assessment required by Section 666 Act 2. The assessment of which option was more likely to address the reoffending risk.
And this apparent omission, this lack of explicit finding.
Yeah, that became the absolute crux of it.
And so very eye of the legal storm, really. The question that would echo all the way up the courts was, could a general statement about considering the ICO and paramount safety actually satisfy that very precise statutory duty to perform a comparative assessment?
Spun on. And this is where the legal teams become so important. At the district court appeal stage, Ms. Stanley was represented by solicitors from Legal Aid NSW.
Okay.
And the Crown, the Director of Public Prosecutions, was represented by the Solicitor for Public Prosecutions, NSW. While our sources don't name the specific barrister for Ms. Stanley at this district court stage, the instructing solicitors were definitely pushing this point about the missing Section 662 assessment.
Right. So the district court sides against Ms. Stanley, maintains the full-time custody sentence. What happens next?
Well, following that district court decision, Ms. Stanley's team took a pretty extraordinary step. They sought review from the Supreme Court of New South Wales, specifically its Court of Appeal, but they didn't do it through a standard appeal against the sentence.
Okay.
They used a process called judicial review. They filed a summons seeking certiorari.
Certiorari. That's a legal order asking the higher court to basically quash or invalidate the lower court's decision.
That's it. You're asking the Supreme Court to say the district court's decision was legally flawed and should be overturned.
But why judicial review? Why not just appeal the sentence again to the Court of Appeal? Was that not allowed?
Not easily, no. Our sources point to a significant hurdle here, something called a privative clause in the District Court Act, Section 176. This clause severely limited the Supreme Court's power to interfere with district court appeal decisions like this one.
Ah, okay. So it wasn't a wide open door.
Not at all.
Yeah.
Under that privative clause, the Supreme Court could only step in if the district court judge had made a jurisdictional error.
Right, jurisdictional error. Let's unpack that because it sounds important. It's different from just, getting the law wrong, isn't it?
It's a crucial distinction, absolutely. A standard error of law is like making a mistake within the boundaries of your job. Maybe you applied the wrong legal test or misinterpreted some evidence. You got the answer wrong, but you were fundamentally doing the right task.
Okay.
A jurisdictional error, however, is far more fundamental. It means the court acted outside its lawful power entirely, or it fundamentally misunderstood the nature of the legal task it was supposed to be performing.
Ah, okay. So it's like way more serious than just getting the calculation wrong. It goes to their actual authority.
Exactly. It's like not just getting the answer wrong, but maybe attempting to answer the wrong question altogether, or using a completely flawed process. It goes to the very authority of the court to make that particular decision in the first place.
Got it. So that was the very narrow path Ms. Stanley's team had to argue through.
Precisely. So the Court of Appeal heard this judicial review application. It was a significant bench, 5 judges. President Bell, Justice Baston, Justice Leeming, Justice McCallum, and Justice Beach-Jones.
Wow, 5 judges. That signals they took it seriously. Who are the barristers arguing it?
For Miss Stanley, the barristers were Mr. T. Quilter, appearing with Miss E. O'Neill. And representing the Director of Public Prosecutions was Senior Counsel Ms. K. Richardson, S.C. with Mrs. C.O. Gleason. The Court of Appeal handed down its judgment on 21 December 2021. And by a majority of 4-1, they dismissed Ms. Stanley's application.
So the majority sided with the DPP again. What was their thinking? Why wasn't the failure to do the Section 66-2 assessment a jurisdictional error in their view?
Well, the majority judges, President Bell and Justices Bastin, Leeming, and Beach-Jones, they either assumed, or in Justice Beach-Jones's case explicitly found, that Judge Williams hadn't actually undertaken that specific Section 662 assessment.
Okay.
But, crucially, they concluded that this failure, even if it was an error of law, did not cross that high threshold into being a jurisdictional error. In their view, the judge was still acting within her sentencing jurisdiction, even if she'd made a mistake in how she applied the relevant considerations.
But it wasn't unanimous. There was a dissent.
That's right. Justice McCallum disagreed. She took a different view, finding that the failure to perform the Section 662 assessment was a fundamental error that did amount to jurisdictional error. The fact that judges at this very high level disagreed so strongly just underscores how complex and finely balanced this legal question really was. This stage really sharpened the arguments and, set the stage for the ultimate legal battle.
So, despite the setback in the Court of Appeal, Ms. Stanley's team kept going.
They did. Undeterred, they took the next significant step, seeking special leave to appeal to the High Court of Australia. This is the final court of appeal in the country, the top of the pyramid. The application was filed in early 2022.
Right, but seeking special leave, that's not automatic, is it? It's a crucial filter the High Court uses. What actually happens at that stage?
Exactly. It's a major hurdle.
Yeah.
The special leave hearing took place on 19 August 2022 before two High Court judges, Justice Keene and Justice Elman. This hearing is where the court decides if the case raises a legal point of sufficient public importance or if it has enough arguable merit and prospect of success to justify being heard by the full bench of the High Court.
So they have to convince these two judges it's worth the whole court's time.
Pretty much. Getting leave granted signals the court sees significant legal questions at stake that need clarifying.
And the legal teams changed again for this crucial step?
Yes, there was a change in leadership for Mrs. Stanley's team. Mr. T.A. Game S.C., a senior counsel, now led the argument for her, appearing with Mr. T. Quilter and M.S.A.E. O'Neill. They were still instructed by Legal Aid NSW.
Okay, bringing in the heavy hitters.
Indeed. And for the DPP, the argument was led by Mr. D.T. Kell S.C., who holds the very significant title of the Crown Advocate of NSW. He appeared with Mrs. C.O. Gleason, instructed by the Solicitor for Public Prosecutions, NSW.
The Crown Advocate himself. That really signals how important the state of New South Wales viewed this challenge, doesn't it?
Absolutely. It shows the state was taking this very seriously.
Looking at the transcript excerpts from that special leave hearing, you can almost feel the weight of the arguments. What were the core points Mrs. Stanley's team, led by Mr. Game S.C., were really pushing?
Well, Mr. Game S.C. argued really forcefully that Section 66-2 imposed a jurisdictional requirement, meaning it was a fundamental step that the judge had to step through to correctly exercise their power when deciding on an ICO. He was saying basically that failing to do this specific assessment went right to the heart of the court's proper function.
Not just a procedural hiccup.
No, much more than that. He also linked it to broader issues, suggesting that if such a fundamental error wasn't seen as jurisdictional, it could seriously limit access to judicial review, potentially even impacting constitutional rights down the line.
And how did the DPP, represented by the Crown Advocate, counter that? What was their argument for why the High Court shouldn't hear the full case?
Mr. Kell S.C. for the DPP argued essentially three things: that the case didn't raise a point of general legal principle needing High Court clarification, that it lacked sufficient prospects of success anyway, and crucially, that Section 662 was just a bespoke New South Wales provision. Meaning, he argued, its interpretation was already sorted out by that 5-judge Court of Appeal decision. He was effectively saying, look, this is just a NSW issue, it's settled, nothing for the High Court to see here.
But the High Court judges, Keene and Edelman, they obviously disagreed with that assessment because the outcome was...
Special leave was granted.
Huge moment for Miss Stanley and her legal team, I imagine.
Absolutely. A major step forward. Getting special leave meant the High Court agreed. The case raised important legal questions that the full court needed to consider.
Okay, so special leave granted. Now we're heading into the main event, the full appeal before the High Court.
That's right. The formal process kicked off with Miss Stanley's team filing the appellant's notice of appeal on 26 August 2022. Interestingly, the DPP responded by filing something called a notice of contention on 2 December 2022.
A notice of contention. What's the point of that at this stage? Are they just digging their heels in?
Well, yes, they were still arguing against the appeal, but the notice of contention also allowed them to raise an alternative argument, a sort of fallback position. They contended that even if the High Court found the Court of Appeal was wrong about jurisdictional error, they argued that the original district court judge, Judge Williams, had actually implicitly undertaken the required Section 662 assessment, even if she didn't spell it out in her reasons.
So a plan B. Even if you think this could be jurisdictional error, she actually did do the assessment implicitly, so the error didn't happen.
Exactly, covering their bases.
Okay. So when was the main hearing, the full appeal?
The main event, the full appeal hearing, took place on 15 November 2022, and it was heard by a full bench of 7 High Court judges. Chief Justice Kiefel, Justice Gagler, Justice Gordon, Justice Edelman, Justice Stewart, Justice Gleeson, and Justice Jaggi. 7
judges. The whole court, essentially,
Yeah.
and the legal teams. Any more changes?
The teams were largely consistent with the special leave stage. Mr. T.A. Game SC, again with Mr. T. Quilter and MSCE O'Neill, appeared for Ms. Stanley, instructed by Legal Aid NSW. For the DPP, Ms. C.O. Gleeson now led the argument in court, appearing with Mrs. A. Pukchansky, instructed by the Solicitor for Public Prosecutions, NSW.
Right. So 7 judges on the bench, top lawyers on both sides. What was the absolute core legal question they had to wrestle with in this final battle? It all came down to.
It really boiled down to this. Was that requirement in Section 662, the comparative assessment, a condition precedent or a jurisdictional fact? Meaning, was it something that absolutely had to be done for the court to even have the lawful authority to decide how the sentence was served, ICO or prison?
Okay, like a gateway you have to pass through.
Sort of. Or was it merely a mandatory consideration? Something the judge must think about, sure. But a failure to spell it out was just an error within her existing sentencing power. An error of law, maybe? But not an error that nullified the whole decision. That's the fundamental difference between a simple mistake and a power-invalidating jurisdictional error.
Let's break down the arguments then. What was Team Stanley, led by Mr. Game SC, really hammering home to the High Court?
Their argument was that Section 662 was much more than just another factor to consider. They called it a fundamental, non-negotiable requirement, a discrete exercise that had to happen after the judge decided on the prison term length, but before choosing between full-time custody and an ICO.
A distinct step.
Yes. They contended that failing to perform this specific comparative assessment meant the judge didn't properly exercise her lawful power, or fundamentally misunderstood the specific function Parliament intended her to perform at that crucial point. They linked this to why Parliament created ICOs in the first place. Rehabilitation, reducing reoffending, and the need for review rights when critical steps are missed. They also pointed out where Section 66 sits in the Act in a whole division titled Restrictions on Power.
Implying it limits the power itself. Okay. And what was the argument from the DPP side, now led by Ms. Gleeson? How did they push back?
They maintained their position that Section 662 was simply a mandatory consideration that Judge Williams was obliged to take into account within her existing valid sentencing jurisdiction. They emphasized that sentencing is inherently complex and evaluative of process. They cited cases like Markarian for that.
So part of the judge's overall job, not a separate hurdle.
That was their core point. They argued that not explicitly detailing the Section 66-2 assessment might maybe be an error of law, something that could potentially be fixed on a standard appeal if one was available, but it definitely wasn't a jurisdictional error that made the decision void. Especially, they argued, given that privative clause trying to limit review. They were also likely concerned about the practical consequences, the potential chaos, if lots of sentences could suddenly be invalidated based on this kind of argument.
And underlying all of this was a deep dive into statutory construction, basically, trying to figure out what Parliament intended the consequences to be if a judge didn't comply with Section 662.
Absolutely. And what became particularly important here was looking closely at the rest of the CSP Act.
How so?
Well, the lawyers noted that in other sections of the Act, Parliament had included specific saving provisions clauses that explicitly say failure to comply with this particular section does not invalidate the sentence.
Like an escape clause for certain errors.
Exactly. But crucially, there was no such saving provision attached to Section 66, and both sides drew very different conclusions from that silence. Stanley's team argued the absence meant noncompliance could invalidate, while the DPP likely argued it didn't mean anything significant.
Okay, so the arguments are made, the 7 judges deliberate. What was the final verdict?
On 15 November 2022, the High Court delivered its judgment. And it was incredibly close, a 4.3 split decision. The High Court allowed the appeal by that narrow majority.
4-3. Who was in the majority?
The majority were Justice Gordon, Justice Edelman, Justice Stewart, and Justice Gleeson. The dissenters were Chief Justice Kiefel, Justice Gagler, and Justice Jega.
So, by the slimmest margin, the High Court agreed with Ms. Stanley's argument. What was their key finding then?
Their key finding was that Section 66 does impose a limitation on the sentencing court's jurisdiction, specifically when it comes to deciding the manner in which a sentence of imprisonment is to be served. That choice between full-time prison and an ICO.
And how did they explain why a failure to perform that Section 662 assessment was a jurisdictional error, going beyond just a simple mistake?
Well, they reasoned that failing to undertake that specific comparative assessment wasn't just an error within the judge's function. It actually showed a misconception of the function itself. It showed a failure to ask the right question that Parliament required when deciding between an ICO and full-time detention.
So, misunderstanding the job at that point.
Yes. They emphasized that the power to make an ICO under Section 7 is a subsequent and separate decision to be made after a sentence of imprisonment is imposed. It's a distinct step, they said, with its own specific requirements imposed by Section 66.
And did that statutory construction point, the absence of a saving clause, play a role?
It did. The majority paid significant attention to that. They highlighted the absence of an express saving provision in Section 66, contrasting it with other sections in the Act where Parliament did include one. For them, this strengthened the view that Parliament intended non-compliance with Section 662 could indeed lead to invalidity.
So what was the final outcome of the High Court's decision for this specific case?
The outcome was that the High Court set aside the orders made by both the Court of Appeal and the District Court. The case was then remitted, essentially sent back down to the District Court for the sentencing decision regarding the ICO to be redetermined according to law, this time making sure the Section 66.2 assessment was properly done.
Right. And our sources don't tell us what happened to Ms. Stanley after it went back down.
No, the judgments focus on the legal principle, not the final sentencing outcome after remittal.
And just quickly, the dissenters, Chief Justice Kiefel, Gagler, and Sheget JJ. How did they see it differently, just briefly?
Very briefly, the dissenting judges generally agreed with the Court of Appeal majority. They viewed Section 66.2 as a mandatory consideration the judge had to factor in within her existing sentencing jurisdiction, not as a fundamental condition going to her power itself. And some of the dissenters also felt that maybe the district court judge had implicitly considered the necessary factors, even without spelling it all out.
Okay, so a really significant decision and a close one. What has the impact been? How has Stanley v. DPP, NSW, actually changed legal practice?
Oh, the impact has been clear and significant, particularly in New South Wales sentencing law, obviously. It really stands as a pivotal case for understanding the boundaries of judicial power and this whole concept of jurisdictional error in the sentencing context. The most direct consequences on day-to-day sentencing practice in NSW courts, especially the district court. The High Court's decision has mandated a much more explicit and demonstrable engagement with that Section 662 assessment whenever judges are considering an ICO.
So for judges and lawyers in NSW, this means you can't just give it lip service anymore. You can't just say, yep, considered community safety, considered the ICO. You have to actually show you're working on that precise comparative assessment. You know, which option, ICO or prison, is more likely to address the reoffending risk.
Exactly. It elevates that specific statutory step. It's not just a general factor anymore. It's treated as a fundamental requirement for the lawful exercise of the power to make an ICO and NSW. You have to demonstrably perform the comparison.
Right.
So the decision reinforces that community safety, as Parliament defined it in Section 66, must be assessed in this specific comparative way. It's definitely led to enhanced scrutiny of sentencing judgments and a much greater emphasis on clear, explicit judicial reasoning that precisely follows what the legislation demands.
And on a broader level, the case has sort of refined our understanding of when a mistake by a court crosses that critical line into jurisdictional error, especially where appeal rights might be limited, like with those privative clauses we talked about.
Absolutely. It's a decision that will influence how judges approach specific statutory duties in sentencing, and potentially other areas too, for years to come.
As we wrap up this deep dive, it's really striking to reflect on how the precise wording Parliament chooses in a law, you know? and how a judge handles that specific wording can trigger such a lengthy and ultimately significant legal battle. It really reshapes practice across an entire state.
It really does.
It shows the immense complexity of interpreting laws and just how critically important it is for judges to adhere meticulously to these legislative directions, especially when someone's liberty is hanging in the balance.
Absolutely. And Stanley v. DPP, NSW, wasn't just about one sentence for one individual, was it? It was about the fundamental nature of judicial power itself, the boundaries the Parliament sets, and the checks and balances on how judges exercise that power, particularly when it comes to alternatives to prison like the ICO.
And what's fascinating here is those specific phrases baked into the law, must assess, paramount consideration, they become the actual battleground. They determine whether a judicial mistake means the decision is simply flawed but stands, unless a normal appeal fixes it, if one's even possible, or whether it's fundamentally void because the court didn't follow the legally required steps to even get to that decision point. It's all about the consequence of noncompliance. Exactly. And that leaves you, the listener, to ponder. In a system that's constantly trying to balance individual liberty with community safety, how crucial is it that every specific step mandated by the law is not only followed, but is also clearly and demonstrably shown in the court's decisions? This case is such a powerful illustration of how one individual's challenge, rooted in a specific judicial omission, can lead the highest court in the land to clarify exactly how judges must perform a critical aspect of their sentencing duty. Thanks for joining us on this deep dive.